Good afternoon and welcome to Abortion at a Crossroads, Bracing for the Impact of American Bans. I am grateful to the University of Ottawa's Centre for Health Law Policy and Ethics and to the Shirley Greenberg Chair for Women in the Legal Profession for jointly sponsoring us today. My name is Daphne Gilbert and I'm a professor at the Faculty of Law at the University of Ottawa. I teach criminal and constitutional law, and I serve on the boards of two international sexual and reproductive justice organizations, Women Help Women and Fos Feministe Canada. I'm going to begin today by giving us an overview of the decision by the United States Supreme Court in Dobbs versus Jackson Women's Health, which overrules the iconic 1973 decision, Roe v. Wade. I will then turn it over to Professor Joanna Erdman, who holds the McBain Chair in Health Law and Policy at the Schulich School of Law at Dalhousie University in Halifax. Professor Erdman chairs the Global Health Advisory Committee of the Public Health Program and serves on the advisory board of the women's rights program, Open Society Foundations. Her research focuses on sexual and reproductive health law in a transnational context. She will give us her sense of the impact of the Dobbs decision here in Canada. Following Professor Erdman will be Professor Rebecca Cook. Professor Cook is a professor emeritus at the Faculty of Law, the Faculty of Medicine, and the Joint Center for Bioethics at the University of Toronto, and co-director of the International Reproductive and Sexual Health Law Program at the University of Toronto. Her published books include Abortion Law in Transnational Perspective, Cases and Controversies. She's a member of the Order of Canada and a fellow of the Royal Society of Canada, and she will offer some thoughts on the criminal, constitutional, and administrative law aspects of abortion from a comparative law perspective. And finally, we will hear from Professor Vanessa Gruben. Professor Gruben is my colleague at the Faculty of Law at uOttawa and a fellow member of the Center for Health Law Policy and Ethics. Her research and writing focuses on various aspects of health law, including reproductive health and the regulation of healthcare professionals. She sits on the board of AMS and the Canadian Health Coalition, and she will offer some thoughts on the potential reach of limits or bans on abortion into other sexual and reproductive health rights. Please feel free to use the Q&A function to ask questions, and we should have time at the end of our presentation to answer them. And so first, to summarize Dobbs versus Jackson Women's Health, I am trying here to give a mostly narrative summary with only a few comments of my own thrown in where I absolutely could not stop myself. After the unprecedented leak of a draft version of Justice Alito's reasons in May 2022, the official decision on June 24th was not a surprise. The vote to overturn Roe versus Wade was a 5-4 vote. Justices Clarence Thomas, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett joined Justice Alito's opinion. 3 of the 5 members of the conservative wing of the court are Trump appointees. Chief Justice John Roberts added his 5th vote to uphold the Mississippi law being challenged in the case, though he would not have overruled Roe v. Wade. The court's 3 liberal members, Justices Stephen Breyer, Sonia Sotomayor, and Elena Kagan, filed a rare jointly written dissent. The decision in Dobbs arose from a challenge to a 2018 Mississippi law that bans virtually all abortions after the 15th week of pregnancy. The law carves out exceptions for medical emergencies in cases involving a severe fetal abnormality, but it does not make any exception for cases involving rape or incest. That law never went into effect, however, because the lower courts, including the very conservative U.S. Court of Appeals for the Fifth Circuit, found that it was inconsistent with Roe and with the other main abortion rights precedent case called Casey versus Planned Parenthood of Pennsylvania, and they blocked the state from enforcing the law. This decision in Dobbs on June 24th reversed those lower courts and upheld the law. Justice Alito's 79-page decision is the main set of reasons for the court. And he begins by observing that abortion, quote, presents a profound moral issue on which Americans hold sharply conflicting views. The thrust of his decision is that the Constitution of the United States does not refer anywhere in its text to abortion at all. The Roe v. Wade decision had located a right to abortion in a right to privacy, which Justice Blackmun, who was the main author of the Roe decision, said was protected by various sections of the Bill of Rights. Privacy is also not expressly mentioned in the Bill of Rights. In Casey, the Supreme Court said a right to abortion was encompassed in a right to liberty, and it was protected by the 14th Amendment. Justice O'Connor, who was the main author in Casey, also recognized certain fundamental rights as constitutionally protected by the 14th Amendment, even though they are not expressly mentioned in the Constitution. And she called abortion one of those fundamental rights. In overruling Casey and Roe, Alito explained that for fundamental rights to be constitutionally protected, they must be, quote, deeply rooted in our nation's history. In his position, until the second half of the 20th century, there was no support in US law for a right to an abortion, and most states regarded abortion as a crime. Justice Alito is one of the 4 originalists in the court, judges who use a methodology in analyzing American constitutional law that relies heavily on the written text and on the state of affairs at the time of the drafting of the Constitution in the late 18th century. In his account of state practice, however, Justice Alito presents a very slanted version of history, ignoring the fact that the common law made abortion accessible early in pregnancy. And he further ignores the racist and sexist judgments that were baked into the campaign to prohibit abortion. When the states moved to criminalize abortion beginning in the mid-19th century, it was based on the view that was shared by the Supreme Court of that era, that a woman's proper role was to bear and raise children. It was also founded in racist fears that white Protestant women were ignoring their maternal duties and having fewer children at the time when immigrant populations were expanding. Alito referred to only a version of history from a short slice of time in deciding that abortion rights are not deeply rooted. Whatever the state of written law, we all know that women have obtained abortions in a myriad of ways for thousands of years. Alito continued on in his judgment to say that even though the Supreme Court's decisions in Roe and Casey established a constitutional right to abortion, those decisions should be overruled despite the principle of stare decisis. Stare decisis is the idea that courts should not overturn their prior precedent unless there is a very compelling reason to do so. Stare decisis, Alito stressed, is not a straitjacket when a ruling is grievously incorrect. And that is how he described the Roe decision. He said it was egregiously wrong and deeply damaging, and therefore, along with Casey, should not be allowed to stand. He criticized the writing of Roe as being vague and unprincipled, and he was quite disparaging of the court that allowed Roe to be issued. Instead, he concluded the issue of abortion should return to the people's representatives, that access to abortion should be a matter for electors in each state. It is interesting to note that in her reasons in Casey in 1993, Justice O'Connor spoke about the incredible value of stare decisis and specifically referred to 2 canons, Roe and Brown versus Board of Education, as the 2 moments where the United States Supreme Court had spoken directly to the nation on issues that were deeply divisive. In her mind, that's a reason not to overrule Roe and to keep it as good law in the United States. Alito insisted that his decision in Dobbs would not undermine other decisions by the court involving fundamental rights that the Constitution does not expressly mention, such as the right to contraception in Griswold, the rights to same-sex intimacy in Lawrence v. Texas, and marriage equality in Obergefell. Unlike those rights, Alito wrote, abortion is distinct, it is unique. It terminates a potential life, what the Mississippi law refers to as an unborn human being. And this is language that Justice Alito adopts when he's speaking about abortion. Nothing in this opinion, he says, should be understood to cast doubt on precedents that do not concern abortion. Because abortion does not involve a fundamental right, the Mississippi law only had to be subjected to the most lenient standard of review known as rational basis scrutiny. This is the lowest tier of review in constitutional methodology in the United States and only requires that a law be rational in order to survive. He cited 2 interests that Mississippi brought forward as to why their law was rational. First, that they had an interest in protecting the life of the unborn. And secondly, because the procedure commonly used for abortions after the 15th week was what they described as barbaric and demeaning to the medical profession. He concluded, therefore, that their prohibition on abortion after 15 weeks was rational and could stand. Chief Justice Roberts concurred with the court that the Mississippi law was a good law, and he would have upheld it too. He just would not have overruled Roe v. Wade. He said states should be allowed to continue to regulate abortion without regard to whether the fetus has become viable. That is the point at which it can survive outside the womb. In Casey, the court had said that states could not ban abortions before the point of viability, which is about 22 to 24 weeks. To Roberts, the viability line did not make sense. So he would have abandoned the timing rule and said that the right to terminate a pregnancy should extend far enough to ensure a reasonable opportunity to choose, but need not extend any further. The other two concurring judgments were from Justices Kavanaugh and Thomas. Justice Kavanaugh wrote a separate opinion in which he emphasized that the Constitution is neutral on abortion, and therefore the court had to be scrupulously neutral on the question as well. He said, quote, "The 9 unelected members of this court do not possess the constitutional authority to override the democratic process and to decree either a pro-life or pro-choice abortion policy for all 330 million people in the United States." He also stressed the limits of Dobbs and said that it should not be extended to or cast any doubt on decisions like Griswold or Obergefell. It was solely a decision concerned with abortion. But that was not the view of Justice Thomas. He indicated that for him, decisions like Griswold, Lawrence, and Obergefell are very much in doubt. He reiterated his view that the Constitution's due process clause only protects process, the right to have the government follow proper procedures before taking away someone's life, liberty, or property. The due process clause, Thomas wrote, does not protect substantive rights. Because the Alito opinion concluded that there is no right to abortion, he joined it, but he said in future he would like the court to reject the other substantive due process cases like Griswold, Lawrence, and Obergefell. Justices Breyer, Sotomayor, and Kagan wrote a rare joint dissent. All three of them signed on to the same dissent. And they pushed back against the majority's characterization of the decision as merely leaving the issue of abortion to the states. They said, "We believe in a constitution that puts some issues off limits to majority rule." The dissenters also criticized Justice Kavanaugh's depiction of the ruling as neutral on abortion. The court said, the dissenters said that they do not act neutrally when it leaves everything up to the states. Rather, the courts act neutrally when it protects the rights against all comers. Kavanaugh's position, they insisted, was a brook no compromise refusal to recognize a woman's right to choose. And they warned that despite assurances to the contrary, no one should feel confident that this majority, and that's how they described it, the group of 5, this majority is done with its work. The right to an abortion at the core of Roe and Casey is part of the same constitutional fabric as the rights to contraception and same-sex intimacy in marriage. And quote, "Either the mass of the majority's opinion is hypocrisy or additional constitutional rights are under threat. It is one or the other." They closed out their 60-page dissent by arguing that the ruling undermined the legitimacy of the court. In Casey, Justice O'Connor had insisted that respecting the precedent value of Roe was vital to protecting the court's integrity. In that case, she said, "The public should never conclude that its constitutional protections hung by a thread, that a new majority could, by dint of numbers alone, expunge their rights." In Dobbs, the dissenters argued that in overruling Roe and Casey, the court was betraying its guiding principles. And notably, they concluded their judgment by saying only that they dissented, omitting the word respectfully that commonly accompanies the dissent. Aside from the decision itself and what it means for access to abortion in the United States, I think there are several catastrophic consequences for the court and for the rule of law. First, 13 states had trigger laws that were written to take effect if Roe was ever overturned. For example, in Kentucky, Louisiana, and South Dakota, abortion bans immediately came into place the day that Dobbs was handed down. In Idaho, Texas, and Tennessee, bans will come into effect when the Dobbs ruling is officially transmitted to all the courts on July 25th. Some states have laws that need to be recertified by legislators, but that is expected to happen easily and actually has happened already in some of these states, and that would be North Dakota, Wyoming, Arkansas, Mississippi, Utah, Oklahoma, and Missouri. And then there are many states that have old unenforced abortion bans or pre-Roe bans that are still on the books that could be brought back. For example, on Monday of this week, the Supreme Court issued an order allowing Indiana to begin enforcing a state law requiring parental consent in order for a minor to get an abortion. Altogether, 26 states are likely to ban or severely restrict access to abortion. Second, I agree with the dissent that Dobbs imperils all other decisions based on fundamental rights. This week, presidential hopeful and Texas Senator Ted Cruz said the court should have overruled all the decisions that are based on fundamental rights, including Obergefell and marriage equality. And I think that issue will be brought squarely to the court and to legislators in the upcoming term. And third, because of the leak of the draft decision and then the tone of the case, the tone of the judges speaking to each other in the case, I think it reveals a chaotic US Supreme Court that is brazenly ideological and deeply divided. And that does not bode well, in my opinion, for any controversial decision it might have to make in the future. So I hope that brief summary situates why we have convened this panel of experts to talk about now what the greater impact of the Dobbs decision is going to be both in Canada and internationally. And so I will turn it over now to Professor Erdman to talk to us about Canada.
Great, thanks so much, Daphne. And I'll just make sure that you can hear me all right. Perfect. So it's really wonderful to be here together with you all. And I want to thank so much, Daphne, for pulling us together. As you said, my task today is to share some thoughts on the Canadian refraction of Dobbs. So what happened when the opinion leaked into Canada? What happened when the judgment came down? When Roe v. Wade was overturned? What questions for Canada did it raise? What reactions did it provoke? And I want to last ask, what new futures did it set on our horizon? So when all of that happened, I know that all of the panelists here today received a flurry of journalist calls. And the primary question that they all asked was, could it happen here? What are our abortion rights in Canada? Are they constitutionally protected? Are they constitutionally recognized? Could they be legislatively voided or judicially overturned? And to answer this primary question, I want to make reference to a 1989 article that I recently came across, and it's titled Canada's Roe: The Canadian Abortion Decision and Its Implications for American Constitutional Law and Theory. And of course, this article is referencing our 1988 Supreme Court judgment, R v. Morgentaler. This was the case, just to familiarize everyone, in which our Supreme Court struck down the criminal abortion restrictions, which were basically a system of hospital committee authorization of therapeutic need, and the court declared those provisions unconstitutional, a violation of charter rights. Now, in talking about Morgentaler, again, Canada's Roe, this article begins by noting our distinct constitutional tradition, specifically referencing parliamentary supremacy. And it was thought, and at the time the article was written, that this doctrine would have led the Canadian Charter to have been interpreted in a restrictive and deferential way by the court. But that's not what happened in the Morgentaler judgment. In fact, Morgentaler became as significant as Roe in our history of judicial review because it shared some characteristics. Much like SCOTUS, our Supreme Court granted constitutional protection to abortion rights through the general language of Section 7, and specifically the right to security of person. But at the same time, and perhaps unlike Roe, there were elements of judicial restraint in Morgentaler. Aspects of the court's reasoning that might have permitted, this article specifically lays out, some revised criminal abortion law to be adopted in the country. That is, if Parliament could have passed one. But we know the history here. Canadian Parliament politically could not adopt a law. It never managed the votes to do so. And as a consequence, until today, Canada has no abortion law, criminal or otherwise. We have no statute that uniquely regulates abortion or uniquely regulates acts taken to end a pregnancy. So when Dobbs first leaked, some Canadian legal commentators really emphasized these restrained elements of Morgentaler and these restrained elements of our abortion rights. And some even went so far as to suggest that Canadian constitutional law had never protected the, quote, right to abortion. But I have to say that I think their restraint was misplaced. I terribly disagree with this commentary, and I do so because our abortion rights are cut from a very different cloth, a different constitutional history, a different constitutional tradition. And I think that tradition is one in which we would not return to the text of 1982. We would not return to a 1988 Supreme Court judgment to decide the scope and meaning of abortion rights today. I truly believe that if there was to be a Canadian Supreme Court judgment on abortion rights today, it would read differently than Morgentaler. It would not link abortion exclusively to medical care. Instead, Canadian abortion rights would be central to the democratic condition. They would be fundamental to equality and justice in social and economic life. And the truth is that Justice Bertha Wilson wrote that judgment in Morgentaler. She concurred with the plurality's opinion on security of the person, but she also wrote her own opinion in the name of liberty. She wrote of reproductive freedom as the heart of a democratic political tradition. And she wrote that as the truth of abortion rights is just no more fundamental than any other civil and political right, freedom of religion, association, freedom of conscience. And this, for me, is the simple constitutional fact. In the decades since Morgentaler, it is Justice Wilson's judgment that has been widely endorsed and which has often been taken to represent the ruling as a whole. And so maybe people forget, but immediately after the Morgentaler judgment, the abortion rights didn't hold. Instead, every province moved to restrict funding on abortion or to otherwise limit access to care. And so I'm not saying that this was the abortion right that was immediately understood in 1988. Rather, I want us to remember that for decades after Morgentaler, there was political engagement and agitation over these provincial restrictions. And then there were legal challenge after challenge that forged a new set of abortion rights. These were fulsome and robust, democratic and collective in character. And they were abortion rights in which state power, and these are the words of Hester Lessard, was the facilitator of our rights, not antithetical to our freedom. So abortion rights in Canada have changed immensely since R.V. Morgentaler. You just need to look at the recent submissions on the constitutional challenge to some of the last standing legal barriers in this country. Specifically, I'm thinking here of the CCLA challenge to New Brunswick regulations. And you'll see here again, abortion rights are being claimed as something more than access to a single healthcare service. You'll see in those submissions, reproductive justice claimed as constitutional justice. And I have to say as well that not only have these abortion rights been claimed, they are and have been recognized. And here I'll point to what happened in Prince Edward Island. In 2016, activists in PEI served notice on the Premier of their intention to challenge that province's restrictive abortion policy and to really bring local and safe abortion care back to the island. But many of you might not know of the PEI abortion case because the activists never had the chance or even the need to win the legal challenge. They actually didn't even litigate the case. And this is because within months, the Premier of PEI announced that his government would not contest the challenge. He agreed that the provincial policy was likely unconstitutional, and he said this in the media. He said, "The character of all places changes and evolves. It's one of those things that comes at its time." So I want to make the point that constitutional abortion rights in Canada, they have come into being in no one place at no one time. You can see in this case that the PEI government reformed its abortion policy, not because of a single judicial decision, but because people claimed their rights and they persuaded a Canadian government to respect and protect those rights. So they didn't need a court judgment, really. These were rights made real in government policy. Now, there's another feature of the PEI abortion case that I think is of particular relevance for us today, and I want to pivot on that point. There was some fantastic lawyering in this case by Nasha Najawan and Kelly McMillan, and the reason that they did some great lawyering was because they faced a challenge in claiming abortion rights against an abortion policy that was based not in state interference, like a criminal law, but really state indifference. The injustice of the PEI policy was that it just abandoned people. It left people alone, requiring them to seek and access abortion care mostly off the island with little public resources or support. And when prior governments offered justification for this policy, they simply dismissed people's concerns with the official line that we believe the status quo is working. And I have to say that this is the same disdainful attitude of the Supreme Court majority in Dobbs. This utter lack of concern for people whose lives are so profoundly affected by the law as they've made it. Truly, in Dobbs, as with prior Canadian governments, they could care less about people. They could care less about people desperately seeking information and care, the extraordinary hardship of their efforts in doing so, the unwavering commitment and financial resources necessary to those efforts, and most importantly, the fear and humiliation that people suffered in seeking that care. And so I think on a judgment like Dobbs that reads in that register, it has been a rather special moment in our abortion rights history that rather than abortion rights of state indifference, the Canadian government has moved to show that it cares. The Liberals, upon the leak of Dobbs and then the judgment itself, they have appeared prepared to do anything and everything to protect abortion rights. Specifically, Prime Minister Trudeau said that his government would legislate on abortion rights. And this sparked quite a big debate on the question of whether, in fact, we do need an abortion law in Canada. And I hope that we can unpack some of this debate in conversation. But for now, I want to only say that I think many question the idea of legislating abortion rights in Canada because they question whether or not such a law would answer people's real needs. I think something that the Canadian media has done so well since Dobbs is to share people's diverse experiences of seeking and accessing care in Canada, and specifically focusing on people's real needs in accessing care. And we can chat about all the different kinds of access barriers that exist, but striking and relayed by so many people in so many places nationwide was first the lack of information about abortion care or misinformation about where or how to get abortions, and specifically the lack of information about the availability and public funding for abortion pills. So that was the first big barrier, a lack of information. And the second big barrier was abortion stigma, that people don't know about abortion because people don't talk about their abortions or about abortion, period. And indeed, this led me to reflect that perhaps we too talk too much about abortion rights and abortion law and policy, and we don't talk enough about the blood and guts of abortion. We don't talk enough about the doing and the having of abortions. And I'm not sure that a federal law would answer that. So when I was asked, and I'll conclude on this, my policy advice for Canadian governments on abortion rights, I absolutely advised without blinking the following, which was put abortion pills into people's hands and then provide them with the information and support to use them. Do this for every person who would ever need them, and do it for every person who could put them into the hands of another in need. For me, this was critical advice because of a significant third barrier that people named over and over in media reports, which was abortion access depends on where you live, or specifically living outside of urban settings. And the truth of the matter is abortion pills travel more easily than people. Now, of course, pills in hands wouldn't solve every abortion access problem in Canada. We'll always need safe clinical services and supportive abortion care professionals, but abortion pills in hand is a radical policy aim, and I think a radical future. So how do you do it? First, expand the class of prescribers. We've already moved from physicians to nurse practitioners and midwives. We can ask next, what about pharmacists? pharmacists are now WHO recommended providers of care. And then second, why not make every encounter with a prescriber a meaningful one? Why not advanced provision? Just whenever you go to a prescriber, you have abortion pills so that you have them when you need them, so that you have them when you need to use them, backed up by support. This would also require a reliable supply of pills, but hey, let the Canadian government again ensure it. Line Pharma and other companies, they're willing to support these essential goods. And then I think with advanced prescription, maybe we can rethink the clinical role in abortion care altogether. Maybe we don't need the supervisory role of prescription control. Maybe we need a more supportive clinical role. And so we can legitimately ask now, what if we moved abortion pills over the counter? I think this is such a significant move because it would allow us to support community-based models of care. And those models of care, they've worked for people around the world, and especially they've worked for people who are marginalized from or who have been mistreated in formal healthcare systems. Think about abortion doulas, abortion accompaniers, abortion hotlines, all providing information, comfort, and support. Let us publicly support these people and the incredible efforts they do to help people have the abortions that they want and need. So in the end, and for our future, I would say, imagine that Canada would create a safe environment for every person to have the information and support to have and use abortion pills. In 2022, the World Health Organization, for the first time ever, they issued new global guidance on abortion care. And in that global guidance, they included recommendations for people to safely manage their own abortions. And they also advised on service delivery approaches to support this practice. And I have to tell you that we have not seen any government fully implement these WHO recommendations in a national context. And so my thought is, imagine that Canada would be the first, abortion first on this policy. In moments of crisis, and this is also true of constitutional crisis, governments, they can do extraordinary things. And so maybe that will be our story of Dobbs and the future of abortion rights in Canada, that we will truly make self-managed abortion a real, live, and healthy policy. Thanks so much.
Thank you, Joanna. Professor Cook.
Thank you, Daphne, for organizing this very important conference. I want to address how we might brace for the impact of the American abortion bans by thinking about what we might learn from comparative abortion law and also the 2022 WHO abortion guidelines, which are, as Joanna said, radical. Laws dynamically interact over time by diffusion, reception, transplantation through transnational networks. The panel today and other scholars and activists that I will mention during my talk are all part of this network. And I think it's very important that we think very carefully about how this network might be the counterbalance to this devastating decision in Dobbs. We also have, as Joanna has suggested, a move from surgical abortion to medication abortion, the abortion pill, which is very significant. And we have yet to really grasp the fundamental changes that are needed in how we think about abortion because of this shift from surgical to medical. So the 2022 WHO abortion care guideline is the most comprehensive guidance, recommendations, and best practice statements to date to ensure quality abortion care, effective, efficient access to acceptable patient-centered care, equitable and safe. It's evidence-based that improves the health of individuals and communities. Their methodology in ensuring it's evidence-based is phenomenal. They reviewed the literature, they reviewed the practice, and brought together a remarkable group of people from across the world to make recommendations, and they even go to the extent to say, to explain which recommendations are strong, which are weak, and to make recommendations against certain kinds of care. So what I'd like to do in my talk today is to think about comparative criminal, constitutional, and administrative law, and how we might begin to think about injecting the WHO guidelines. They have made specific recommendations vis-a-vis criminal law, not specifically vis-a-vis criminal, constitutional, and administrative law, but have implications for how we frame criminal, constitutional, and administrative law. So first, criminal law. The use of criminal law in the past has been used to punish women, to, in theory, protect them from unsafe practices. The other rationale is a sex rationale. We have to punish women for non-procreative sex. The third rationale is a fetal focus rationale. We have to protect prenatal life from the moment of conception. Now, each of these rationales have been challenged in public debates in different ways and in court decisions. Of note is the 2010 Portuguese Supreme Court decision, which explained that, yes, protecting prenatal life is an important social value, but it must be done consistently with women's rights. And they set out different ways that this might be done. For example, supporting healthy birth outcomes by improving prenatal care. Ruth Rubio-Morin has discussed this at great length, and it makes, I think it's an argument and a justification that we need to explore in other situations. Now, in addition, constitutional courts around the world have put forward the doctrine that you only use criminal law as a last resort. The 2012 Brazilian Constitutional Court, as explained by now Judge Roberto Barrasso, has used this doctrine of only using criminal law as a last resort in the anencephalic case of the Brazilian Constitutional Court, allowing abortion in cases where there is a fatal fetal anomaly. Similarly, the 2007 Mexico Constitutional Court used this principle of only using the criminal law as a last resort to uphold the Mexico City law, as explained by Alexandro Madrasso. Punishment regimes set out in criminal laws range from 2 years to life imprisonment. The WHO decision, the Mexican 2021 decision said that imprisoning women is a disproportionate way of protecting prenatal life, and in fact allowed women in one of the Mexican states to be released from prison. Finally, in terms of thinking about how these laws, they've punished providers, they punish women, but it should be pointed out that not all laws, criminal laws, punish women. So there might be some opportunities there in some countries. But none of these laws punish men. And as Sally Shelton has so brilliantly explained, these laws are incredibly gendered. They're drafted by men way long ago, such as the 1861 law of the English 1861 law that still prevails in many countries, particularly the Commonwealth Caribbean countries, when women were considered men's possessions. Rather than legal persons, they had no rights to vote or own property. So the gendered nature of these laws is something that I think we need to emphasize more and more, and the gendered nature of the majority decision in Dobbs. So what does the WHO, how does the WHO guideline help us in this area of criminal law? The WHO guideline recommends at its highest level, and the recommendation is at the highest level, it calls for decriminalization. It only suggests that criminal law be used where there's non-consensual abortion, and that can be dealt with by the criminal assault provisions. So those are some ideas on how we begin not only to change laws or think about the use of criminal law, but change the discussion about the use of criminal law by referring to comparative criminal abortion law. Let me turn now to constitutional law. Dobbs is based, Roe is based on there are many ways of thinking about autonomy, and Dobbs based its thinking about autonomy on the right to privacy. But the privacy doctrine has been criticized endlessly. And perhaps a very insightful criticism is by Sandra Fredman, a South African scholar, which criticizes the privacy doctrine because it emphasizes individualism. It negates the interconnectedness of the gender relations that are necessary for childbearing and child rearing. Kathy Albertine, another South African scholar, has criticized the privacy doctrine as only being a negative freedom and not a positive duty of states to ensure reproductive justice. So we have different ways of articulating our understandings of autonomy. And I'm suggesting that we begin to think anew about other ways of thinking about autonomy. Morgenthaler based its decision on security, and as Joanna explained, liberty and conscience. But why haven't we talked more? Why haven't we used more women's rights of conscience, the ability to call their souls their own? Interestingly and significantly, the Colombian Constitutional Court decision of this year bases its reasoning, or some of its reasoning, on women's rights of conscience. Now, the decision is not yet available in English, but will be forthcoming. Isabel Yarmillo of the University of Los Andes is writing up a comment on it, so it will be more widely understood. But understanding the court's reasoning on the women's rights of conscience and how it might be used to expand women's rights of conscience, as was done by the Colombian Supreme Court, will be very important. Another autonomy rationale that is used and is emerging more and more is the right to integrity. The Inter-American Convention on Human Rights talks about the right to integrity. The South African 1996 Constitution also talks about the right to bodily and psychological integrity, which includes the right to make decisions concerning reproduction. There's a case now pending before the Inter-American Court of Human Rights that might also inform how we can think and talk about the right to integrity. The Colombian 2006 decision talks about the right to dignity. When legislatures, and I'm quoting here, when legislatures enact criminal laws, it cannot ignore that women as a human being are entitled to dignity, and that she must not be treated as a reproductive instrument for the human race. Each country is going to decide which of these autonomy principles resonate best in their country, given their history, given their constitutions, given the meanings of autonomy in those particular countries. But I think much can be done to begin to surface the reasoning of these other courts and how they talk about autonomy. The other area that I'd like to mention is how courts are beginning to think about gender non-discrimination and equality. And in particular, the use of the CEDAW General Comment 24, which really emphasizes, CEDAW General Recommendation 24 is their recommendation on their Article 12 on health. It really begins to lay out the concept of transformative equality. General Recommendation 24 explicitly says criminalizing medical procedures that only women need is a form of discrimination. Now, many constitutional courts at the domestic level will play lip service to the CEDAW Convention and General Recommendation 24. But I think much can be done by using this provision of General Recommendation 24 of criminalizing medical procedures that only women need is a form of discrimination, as a way of pushing our thinking towards how we transform our thinking and our structures to ensure women's access to medical care that they only need. Now, you have some important developments in constitutional law, particularly the 2009 decision in the Nepalese Supreme Court, which Melissa Upreti, who is now on the UN Working Group on Discrimination Against Women, has explained. So the Nepalese Supreme Court explicitly said that one has to provide services to ensure the provision of services to poor women. And hence the Nepalese government has moved to ensure that those services are covered by the government. In contrast to some courts, such as the Zimbabwe court, which paid lip service to the CEDAW General Recommendation 24, you have the Croatian 2017 Supreme Court decision, which upheld a liberal law in Croatia on the basis of equality. So if we're really going to think about women as equal citizens, we need, as a network of scholars and activists, to really jumpstart the equality thinking of these courts. Now, in terms of the WHO guidelines, it's very, very significant that WHO, a technical UN agency, in its guidelines explains that the enabling environment for quality abortion care requires respect for human rights, which would be constitutional rights. So it really gives us permission, or more than permission, it requires us to think much more critically about the autonomy principles we use, about the equality doctrines we enable. Let me turn now to administrative law. As abortion laws around the world have been liberalized, yes, they might have allowed extended grounds for abortion, but they have done so by introducing hyperregulation, a term that I really like that Elena Caruso has used on her work on Italy. So hyperregulation comes in many forms. Mandatory waiting periods, third-party authorizations, third-party authorizations for rape, which present a whole host of barriers, particularly for women who have been marginalized. And the WHO guidelines significantly recommends against mandatory waiting periods. In Italy, as Elena Caruso has explained, it's 7 days. The WHO guideline recommends against third-party authorizations, and it does not recommend any gestational limits. And as Joanna said, it also recommends that women herself can do self-managed abortion with a pill. They can use community health workers, nurses, pharmacists, and of course, general practitioners. So administrative law might be an area where we need to include administrative law lawyers in thinking through how we eliminate some of these barriers, how we argue that they are not evidence-based, and to really begin to think, as Joanna explained, that we have to make sure that abortion is available across all sectors of society. In conclusion, comparative abortion law, you really need a telescopic vision to understand how these laws are diffused, transplanted, and received across countries in order to achieve reproductive justice. And here, the discipline of comparative law could be extremely helpful, both civil and common law. Also, you need a microscopic vision and collaboration with local partners to understand how criminal law, constitutional law, and administrative law are applied in one jurisdiction and how they can be reformed to enable access to quality abortion care. So with that, I'll end my comments.
Thank you, Rebecca. Professor Gruben.
Thank you. Thank you, Daphne, for organizing this panel and for including me in this important conversation today. So I'm going to focus my brief comments today on the impact of the Dobbs decision on 3 areas of reproductive health: access to emergency contraception, management of miscarriage, and assisted reproduction. Each of these involve a fertilized egg or embryo. And although people may consider access to these types of healthcare to be quite different from abortion, the ripple effects from the Dobbs decision will likely impact each of these areas. And in fact, we're seeing in the US that that's already occurring. As the dissenting justices in Dobbs noted, the majority's decision goes much further than simply the Mississippi abortion law. It allows states to enact laws that can limit abortion to the moment of fertilization. And so medical services, drugs, or procedures that have an effect on a fetus, embryo, or fertilized egg may be impacted by the Dobbs decisions and state laws that are enacted in response to it. And of course, this may have an impact in Canada, as individuals may well seek out these reproductive health care services in other jurisdictions, including ours. So let's start with emergency contraception. So state laws banning abortion could also result in a ban on emergency contraception like Plan B, even though medical professionals do not consider this to be an abortion medication. Emergency contraception prevents a fertilized egg from implanting into the uterine wall. It does not cause an abortion. However, state laws which criminalize abortion from the moment of fertilization and which do not distinguish an embryo that is implanted into the uterine wall from one that is not implanted could therefore extend and catch emergency contraception. And that's because such a law would consider a person to be pregnant even where the embryo is not implanted. So pharmacies and clinics which stock emergency contraception could be found to be in breach of this type of broad-based abortion ban. This legal result might be unintentional in some states, which just have very broad, unclear laws, but it's quite possible that some states will intentionally draft their abortion laws in such a way as to preclude emergency contraception. In fact, such an approach would align with the position that some pro-life groups have taken in the past, even in the face of broad medical consensus. The second area where we will see and have seen the impact of the Dobbs decision is on management for miscarriage. So state laws that impose blanket restrictions on abortion procedures may either catch medical treatments for miscarriage, or as we're seeing, they may have a chilling effect on the treatment and management of people who are experiencing a miscarriage. So miscarriages, the majority of which occur before 13 weeks, are relatively common. They occur in roughly 10% of all pregnancies. Miscarriage can be treated in a number of ways, including through the use of medication or through surgical procedures. And the approach that's appropriate, in other words, the standard of care, will depend on the individual's circumstances, including their personal preference, given the nature, both the physical and emotional impacts of a miscarriage. Unfortunately, we're starting to see that some professionals are not providing these services, the appropriate medications or surgical procedures, because of fear around the application of these new restrictive abortion laws. Healthcare providers might be reluctant to provide medication in the context of a miscarriage because some of the drugs that are used are the same as those used to induce a medication abortion. Healthcare providers have also expressed concern with surgical evacuation, where the tissue that's no longer viable, the contents of the uterus is removed. There's a concern that they may face criminal liability or may be disciplined by their licensing body, despite the fact that it is the appropriate treatment under the circumstances. As I've mentioned, there are already many reports of patients who are not receiving the care they require in either a timely way or in some cases receiving any care at all. Many American women who are actively miscarrying have shared their gut-wrenching stories of attending hospitals and medical clinics only to be told that they will not provide care because facilities and professionals are worried about being perceived as facilitating an abortion. There are similar stories about delayed and denied care in pharmacies. Some pharmacists have delayed or denied filling prescriptions for medications that are needed to complete a miscarriage or to address complications from pregnancy loss. Indeed, there are some pharmacies that are now imposing additional requirements on dispensing prescriptions for the medications, which again result in delays or may act as a deterrent for people seeking care. Failing to provide appropriate miscarriage care has, of course, devastating impacts. Some people who are denied care and sent home must endure a days-long process whereby they are actively miscarrying. It's often very painful. It's physically and emotionally exhausting. And there are also significant health risks associated with delaying or denying appropriate miscarriage management. So for some patients, when an evacuation is required to remove the non-viable tissue from the uterus, if this doesn't happen in a timely way, the failure to do so can result in hemorrhaging, can result in infections, and even sepsis, which is sometimes life-threatening. Failing to provide appropriate miscarriage care also erodes the trust between the healthcare professional and patient. Interactions with healthcare professionals who delay or deny miscarriage have been reported to be exceptionally difficult. And of course, these stories are just heartbreaking. Women crying in pharmacies because they can't access the medication they need and having to explain to a pharmacist in front of other people in a pharmacy that they're experiencing a miscarriage and desperately need the medication for which they've been prescribed. The third area of reproductive health care that may be impacted by the Dobbs decision and those state laws that follow are around the application and access to assisted reproduction. And those include the laws that govern the disposition of the embryo in IVF and access to certain types of fertility care. So some state laws may impact in vitro fertilization, which occurs, of course, when eggs are fertilized outside the body and then transferred back to the uterus. It's possible that some states may choose to enact broad bans where the termination of a, quote, unborn child is unlawful, and that term unborn child is defined to extend back to the moment of fertilization. Embryos are often destroyed, either intentionally or unintentionally, at various stages of the IVF process. And as a result, these procedures could be impacted by state laws. These laws could raise significant concerns regarding the disposition of embryos in a number of different situations. So for example, where individuals have completed their family building project, they may choose to either destroy unused embryos or donate those embryos for research purposes. There's a question about whether those practices would result in a breach of a criminal abortion ban. Questions about patients who use pre-implantation genetic diagnosis, which allows intended parents to determine whether an embryo carries a certain type of genetic disease, serious type of genetic disease like cystic fibrosis or Huntington's, and gives them an option to choose an embryo that does not carry those genes. What would happen to those unused embryos that carry those genetic diseases in states that criminalize abortion from the moment of fertilization? Some have expressed concern about the inadvertent destruction of frozen embryos. So frozen embryos are used in about 85–90% of IVF cycles. And a percentage of those which have been frozen or subsequently thawed just don't survive that thawing process. They're inadvertently destroyed. Some have questioned whether the inadvertent destruction of those frozen embryos, which happens frequently in fertility clinics, will that be caught by these restrictive state laws? And it's not just sort of a clearly drafted law that advocates, health providers, and scholars are concerned about. They're also concerned about state legislation that has these trigger laws, as you referred to earlier, that Daphne referred to earlier in her comments, that are sort of hastily prepared or that are quite vaguely drafted and might unintentionally capture the disposition of embryos. The American Society for Reproductive Medicine has undertaken a review of 13 of those state trigger laws to determine whether there was potential ambiguities that could impact assisted reproduction. And the Utah law was one where they did find potential issues. Their research revealed that that law could be interpreted as having an impact on assisted reproduction because abortion is defined in terms of the intentional killing or attempted killing of a live unborn child, and the term unborn child is not defined. Some have also speculated that an ambitious prosecutor could rely on vague or ambiguous language to try and test new terrain about the legal status of the embryo. And so perhaps not surprisingly, clinics, hospitals, and healthcare professionals are wary of being subject to such a case and are considering ways to avoid being caught by the law. Some women are opting to undergo implantation of embryos during a less fertile time of their cycle, what's referred to as compassionate transfer, in order to avoid these legal consequences. Some fertility centers are considering relocating to abortion protective states and other jurisdictions. And again, we're starting to see that this is actually starting to happen, that this perception of legal risk has begun to really prompt changes in the delivery of fertility care in some states because of concerns about the legal status of the embryo. There are also likely to be impacts on the delivery of fertility care more broadly as a result of the Dobbs decision. So, for example, it may well be that the clinical approach to embryo transfer might change, whether one embryo transfer or more multiple embryo transfer occurs. That may change because selective or multifetal reduction will no longer be available in states that enact broad-based abortion bans. When an individual has multiple embryos that they can transfer, they may choose to freeze those embryos or to transfer more than one embryo at a time into the uterus. And if more than one embryo is implanted, it's possible that there will be a multiple pregnancy, which carries with it significant health risks for both the pregnant woman and the fetus. Those health risks for a person who's carrying a multiple pregnancy include preterm labor and birth, gestational hypertension, which in turn increases the chances of placental abruption, anemia, postpartum hemorrhage. There are also risks to the fetus as well. In some circumstances where there is a multiple pregnancy, a healthcare provider, an individual may opt for a selective reduction in order to protect the health of the pregnant person, and that will no longer be available. And so we may see a change in clinical practice in IVF care. There are other areas, of course, as well, access to surrogacy, which may be impacted. It may result, these abortion bans may result in fewer people who are willing to act as surrogates in abortion hostile states. They might not be willing to do so anymore because they're concerned about not being able to access the necessary reproductive health care they need during the pregnancy, whether it's miscarriage treatment or access to abortion. And while there may be some workarounds to address some of those concerns, it's likely that we're going to see an impact on access to surrogacy. So what does this all mean for Canada? Well, it's quite possible that individuals who are seeking access to these reproductive health care services will leave the American states, go to other states, or come to other jurisdictions to seek out care. Individuals may seek out emergency contraception in Canadian pharmacies. They may seek access to medications to manage miscarriage from Canadian physicians and pharmacists. In the case of assisted reproduction, maybe that Canada will increasingly become a destination for assisted reproduction. Canada may be considered a safe haven to store and ultimately destroy or donate embryos for research. And so it will be critical for Canadian advocates, healthcare professionals, lawmakers, and others to consider the impact of this, really seismic shift of the Dobbs decision in the US, not only on access to abortion care, but also on accessing these other essential reproductive healthcare services. Thanks very much.
Thank you. Okay, everybody, that was so informative. We do have some questions, so I'm going to direct them initially to someone who I think is best placed to provide an initial answer, but please, all of you, feel free to weigh in if you've got something else to add. I think the first question is for you, Joanna, and it's about abortion, or about pregnancy crisis centers, and why it's important to defund them, why they are harmful, why we should be concerned about those centers. And maybe you could begin by just explaining what those are.
Sure, absolutely, Daphne. So yes, I think the crisis pregnancy centers are defined precisely by not aiding people to keep their children that are wanted, but instead, the defining characteristic of these centers is to mislead people who are seeking abortion care and to deliberately frustrate their access to that care. And so I believe that if you understand centers as operating in that way, whether providing medical-based care or market-based services, their conduct is harmful. And on that basis, absolutely, their activities should be investigated and curtailed. And I believe that that's the approach of government. But equally, I want to just take this opportunity to say that to really redress the harm of these crisis pregnancy centers, I think equally we have to promote information on abortion care. So first and foremost, I'd say no more coat hangers. Yeah, we need to show abortion pills all the time. Let's promote abortion pills. There is a safe way to have abortions. Promote abortion pills on every street corner, every city bus, local billboards. Advertise and support abortion hotlines that if pills are not the right kind of care for you, they can direct you to the right kind of care. You can call to learn more. You can get support during, before, and after your abortion. And then I would just say, let's make abortion highly public, highly visual, make abortion a common life event, if not a really affirming one for people, something that people talk to with their friends and family, because it's truly abortion stigma that creates the vulnerability on which these crisis centers rely. And so, yes, regulate the centers, but also deprive them of the conditions of their abuse, which first and foremost is abortion stigma that keeps abortion secret. And that's exactly why people find themselves in vulnerable situations and how these centers prey on people.
I agree. I just want to add that I know in Toronto and Ottawa, there are more crisis centers than there are abortion clinics, like by far. And so that countering that message, I think, is really important. Yeah. I think this one is a good one for Rebecca maybe to answer. And this is about, you know, what this questioner is called the current hot topic about whether we should be providing abortion care to American women. And I was wondering if you could speak a little bit about that idea of abortion tourism and people crossing country lines. And, you know, we know that that has been in the past, but now we see other countries with more liberal laws than the United States. That used to be the other way around. And maybe you could just talk a little bit about that, about the increasing liberalization of other countries compared to the United States.
Well, I think it's very important that other countries frame their laws so they can provide services to people out of state. Now, some countries don't allow for that, but I think increasingly, given particularly countries bordering on the United States, it will be very important for some women to be able to go to Mexico, different parts of Canada to get care, even possibly to the Caribbean. So I think looking for those countries to look at their legal frameworks to ensure that providers can provide care. In addition, I think we need to, if there are regulations vis-a-vis telehealth, telemedicine, and pills by post, we should make sure our laws would allow for sending the appropriate pills to whoever, wherever they want it.
This is a question I think I would put to all of us here, because it's something that I also am struggling with, and it's an interesting reaction, Joanna, to your discussion about self-managed abortion. That here in Canada, after Dobbs, I was very vocal in my media about how happy I am that here abortion is treated as a medically necessary service, that we have no criminal law, that it's just healthcare, and that's what it is. But then I hear you saying that there's also a big benefit in removing it out of healthcare and putting it into the hands of women through a self-managed abortion movement. And I'm wondering if there is tension in those two ideas, or when we're speaking about where abortion is best placed in Canada, since we all agree that there shouldn't be a standalone law about abortion, where do people think how do we frame that conversation in a way that isn't a dichotomy between those two things?
Should I take it first?
Sure.
Yeah, no, and I think this question, you're right, dovetails really nicely. That there's a question about the demedicalization of abortion and about abortion legalization. Mm-hmm. And the truth is, those two things have always gone together: medicalization and legalization. So you're right. The debates about a Canadian abortion law have been interesting, and I think in a way it was good to have them, because it allowed people to really think about, why is a condition of having no abortion law a good thing? And I think the commentator in the chat said one of the reasons, which is it's actually protective in some way to have no law, because if you had a statute, that could be a way that you get in front of the courts. And actually, it's quite difficult without government action on abortion to get in front of the courts. So it's protective in that way. But the other notes that I saw in this debate were that people were also fearful, not just of a conservative court, but of legislatures starting to actually try to craft abortion laws. And the fear of the process of framing, parliamentary reviews, litigation, that indeed abortion legalization, trying to put abortion and cement it in a law, has often been as denying of abortion rights as criminalization, and often indistinguishable from it. You know, we can look at so many countries worldwide in which we have endless legislative provisions that set out who, where, how an abortion can happen, and they criminalize everything outside of that law. And you know, this is true of new and progressive laws in Europe that were celebrated in Ireland, in the Isle of Man. They had new abortion laws that allowed you to get an abortion in certain conditions, but they also, if you look at these liberal progressive laws, they included new criminal offenses for anybody distributing information about abortion, anyone providing abortion goods or services outside the terms of the law. So I think probably the most persuasive reason not to have an abortion law is because nobody can give me a good reason to have a law. We don't need one. You do not need a law. We have so much evidence from countries worldwide that a legal abortion is not always a good abortion because it asks people to meet conditions which are not meaningful to them, right? To have to meet the conditions of the law. And second, we know that there are so many good abortions that happen outside of the law. And so we have to look at the conditions that really matter. They are access to information, access to a safe supply of quality drugs, supportive networks, social and economic support for people to have the children they want when they want it. So if you ask me, yeah, that's a national policy on reproductive justice. And if somebody wants to put forward ideas about that, I would be 100% with you. But I think it's that holistic idea of supporting, not regulating abortion as part of a much more comprehensive understanding, not just of reproductive health care, but I think reproductive health and lives, right? That's absolutely connected to people's social and economic well-being.
Rebecca, do you have any thoughts about this, about moving away from a medical model?
Just to emphasize a few points that Joanna made, I think one of the things that we've done historically in thinking about abortion is we've forgotten that abortion doesn't happen in a vacuum. And we need to think about the reproductive continuum. We need to understand that abortion mortality is part of maternal mortality. We need to understand how to integrate abortion into other reproductive health services. And I think by having an abortion law, we need to think very carefully whether that really isolates us from thinking about abortion in a reproductive continuum that promotes reproductive health much more generally, that reduces maternal mortality, that promotes contraception, that promotes healthy sexuality. So having an abortion law per se takes us out of that integrated approach to reproductive health care.
Mm-hmm. Rebecca, I have two questions that I think are related that I think perhaps you could help us with. And they're both about the possible liability for healthcare providers in Canada who perform abortions on women coming up from the United States. And I know the CMA has issued a statement saying it would not advise providers right now to do that until things settle and we have a better sense of the landscape. But I'm wondering if you have any thoughts about whether doctors should be worried, what you see as potential risk there.
Well, it depends on what the doctor's worried about. Are they worried about being extradited to the US? If they are, the law on extradition has a rule of double criminality. And there's a very early decision, a Canadian decision on this, I think it was Saskatchewan, that wouldn't allow the extradition of a Canadian doctor to the US because it wasn't clear that in that province abortion was unlawful. So if the doctors, the doctors are worried about being extradited and prosecuted in a particular abortion hostile state in the US, they shouldn't be, and the CMA really should make that very, very clear. So, and they might even issue a specific policy on that and refer back to the jurisprudence that we have in Canada. Now, if doctors are providing abortions here in Canada are worried about liability, I don't, since we have no criminal law on abortion, then I don't think that should be concerned. So I don't understand the basis of the CMA recently issued policy.
I think the concern is, and the reason that they're saying wait, is to see how the laws are drafted in the US. Like, so for example, Missouri is contemplating, this is not related to liability for doctors, but Missouri is contemplating a law on abortion that would capture any child that was conceived, any fetus that was conceived in Missouri, even if the person then left the state, was just passing through on vacation, for example. And if the proof was there that the child was conceived in Missouri, Missouri's law would apply no matter where the pregnant person resided or was. And so I think what we're worrying about is laws, state laws, which say that they will extend their criminal law reach to lay state charges against a doctor, no matter where they might be in the state of, say, Utah, that any doctor who performs an abortion on a woman from Utah could be liable to criminal prosecution in Utah, whether they're in Utah when it happens or not.
Right, but how would you implement that? I mean, you're going to extradite that doctor to Canada? Is that, I don't understand.
Mm-hmm.
I mean, I think this, and maybe the CMA is overreacting, but this is an area where criminal lawyers and medical lawyers could get together and develop a policy that takes the offensive on this, instead of be cautious, but to celebrate what we have in Canada and the liberties that women have in Canada. But it needs work, and it's very concerning that even our CMA is being so cautious.
Mm-hmm. Vanessa, I have a question for you, and that is one that is close to my heart as well, which is a question around how we destigmatize abortion for potential service providers. And so I know that you work in areas where there is stigma around a lot of the kinds of services that are central to the research that you're doing. And I'm wondering what your sense is around providers and whether this kind of decision is going to have a stigmatizing impact on them, even here in Canada.
Yeah, I mean, it's certainly possible that, again, we will see some of these ripple effects of this Dobbs decision outside of the US in our jurisdictions that may impact our providers. I think there are important ways that we can mitigate against those risks, and some of the risks that arose with respect to the last question as well. I think the regulators have an important role in supporting their members. So whether it's the College of Physicians and Surgeons of Ontario or the other provincial colleges, or for the pharmacists, et cetera, they can provide guidance and support to their members, which will in turn destigmatize the care the really critically important care that they're providing to individuals. Addressing stigma can also happen in terms of education and training. So in medical schools, nursing schools, pharmacy programs, getting this kind of information and destigmatizing these important reproductive health care services is really critical. And again, another, just echoing back to what Joanna said, taking some of these services outside of the medical model is also an important way to address stigma. I love Joanna's plug for medication abortion being advertised on buses and lots of information about that. The more information and education that we can provide to Canadians writ large on the importance of abortion care and other types of reproductive health care will play a significant role in addressing the stigma associated with these types of this type of care.
We have a question about the period tracking apps and the concern in the United States that women should delete these apps from their phones or wherever they're using them. And I'm wondering if anyone has any thoughts about not just that particular app, but the idea of the potential reaches of these kinds of abortion laws in terms of the privacy rights of women around their medical records, the conversations they have with doctors, conversations that they're having with other medical professionals, and whether we should be concerned about disclosure requirements, for example, that physicians might have, which would go against everything we know about how medical relationships are usually treated in the law, but whether there should be concern about privacy. Rebecca, go ahead.
Yes, there should definitely be a concern about privacy, but I think that the privacy laws in Canada are really very protective. I mean, we have privacy officials, commissioners, and maybe this is something that should be brought to the attention of these privacy commissioners to bring forth a policy to preempt some of this kind of draconian thinking, at least for Canada, for Canadian women. So they're not continually concerned about this kind of issue. But it's abhorrent that they could be tracked in this way, in a very punitive way. So I think it's something that really needs some thinking, be a great topic for the different centers for health law and policy in Canada at Canadian universities. But privacy is so fundamental to any patient, anybody in any model of care, that it needs to be protected and emphasized as the models of care shift over time.
Mm-hmm. Yeah, go ahead, Joanna.
Yeah, I think I want to just support Rebecca on this. And also I know that there are many providers, medical providers with us this afternoon. And I think what I want to say is that imagining Canada as an abortion safe haven for Americans really puts our providers in a significant role. And I think questions about criminalization of activity, extraterritorial criminalization, about privacy breaches and mandates for disclosure. I mean, we know this history in other hostile places on abortion laws. But what I want to do first is to thank all of the providers and activists who are going to be willing to help, because I think this is going to be extraordinarily hard work, and it's going to be emotionally hard work. And the reason is because of the conditions under which these patients will be seeking care. They will be traveling away from family and community. They'll be under legal threat. They are living in an immensely hostile environment. And so I know that these providers, they will care for people, and they will do so in so much more of a holistic sense than abortion care. And so I understand that providers are scared. And I do think that the answer is really for the government to protect them. They are now human rights defenders, and being able to have that security will be immensely important to them. I have just so much love for providers, and that's why I really reject the idea that demedicalization means that those providers no longer have a role in abortion care. I think Vanessa said it really well. You know, to demedicalize is to really just think of yourself in a different role. There will always be the need for clinical abortion care. And then once you have all of this information and resources and support out there, we know that people will often ask their doctors first. They'll ask their people who they see for healthcare first about information and activities and so forth. So I do think this is a real moment to support our abortion providers, to keep them safe, and really to recognize them for the work that they will do for Americans, but also I think for Canadians in transforming our abortion rights in this country.
Fantastic. I want to end with one question that I think all of us could maybe give a one-liner or a couple of lines on, and that is someone who asked what students can do to advocate for reproductive justice. So if you had to pick one or two things that you would tell the youth of our country going forward, what the top thing is, and I'll start by saying I really want to advocate for the destigmatization of abortion, and I want to advocate for that in medical schools. And I think in medical schools is where we have to start and get more doctors on more of those human rights defenders, more people doing abortions and willing to talk about it and talk about it in a public way. I think is what I want students to really push for. But perhaps Rebecca, do you have a thing that you think that the kids should be doing?
I think students in many faculties have an incredibly important role to play. Mm-hmm. I'm thinking of the very important work that's being done in medical schools in India on introducing gender perspectives on the delivery of healthcare. They have a whole program in Maharashtra state. I think we could be doing the same thing in Canada. We have to think far more holistically about, I think, let me put it this way. I think the issue of abortion and this shift that Dobbs has caused provides a very significant opportunity for how we teach around this subject. And I think that students need to really encourage that we teach in a far more holistic way. We need to introduce into our medical schools, into our law schools, into all kinds of curricula, a much more gender sensitive, gender open approach, not only to abortion, but much more generally. And we have to take that very, very seriously. And I think students can really promote that.
Vanessa?
Well, I think, you've mentioned medical schools. I'll focus on law students. I think that there's lots of advocacy opportunities for law students, both within law schools, and also there's just a bunch of wonderful NGOs and advocacy organizations that they can work with, do internships with, volunteer with if they're interested. And so they should seek out those opportunities, and they can do lots of really important work and advocacy work in this field.
And Joanna, I'll give you the last word.
Thanks. I think that students can also advocate by sharing their experiences of abortion and being there for other people who want to share their experiences with them. I think for so long we advocated abortion rights as something abstract, something legal, and what's really made a difference is people talking about abortion rights in their everyday lives. What abortion means for them, what were their experiences of it. It just has made it such a different place to know providers and their relationships with patients, friends, and how they've supported other friends in their lives. Stories that have been so significant about people talking to their parents, their mothers about abortion, just to know how much abortion is part of our lives. Because to take it away when you know that is something very different than to have it as a medical service locked away in a clinical setting. It's too easy to start regulating it, to start advising on it, to start passing laws on it. And it's a very, very different story when it's something that has been profound in your life and in the lives of people you love. So I think abortion is something that we love and we talk about all the time, will really make a difference in abortion rights advocacy.